Good morning, everyone. I'm Jen Clays from Newborn Medicine, and it's my pleasure to introduce today's Grand Rounds speaker and also to welcome you all. Obviously, we're still virtual due to the flooding in Rangos, but we hope to be back in hybrid mode soon. As a reminder, questions can be posted in the Q&A throughout today's lecture, and you can join us for an informal meet and greet at the end of the presentation by asking the host to unmute you. The CME code will be posted in the chat. Due to the circumstances of the lecture, we will not have a Mock 2 quiz today. I am so honored to introduce today's speaker, Chaton Turner, Esquire, for a presentation on the abortion laws in Pennsylvania. Ms. Turner is a dynamic speaker who seeks to inspire others. She is Associate Counsel at UPMC, focusing on risk management, and she chairs the UPP Center for Fertility and Reproductive Endocrinology Ethics Committee. She also manages the UPMC Intermediation Program, an alternative dispute resolution program for patient grievances. Because of these efforts, Ms. Turner was asked to become an adjunct professor at the University of Pittsburgh School of Law. Ms. Turner is a graduate of the University of Virginia and the University of South Carolina School of Law. Before pursuing her legal career, she was involved in sales and marketing. Ms. Turner is a wife and mother to a kindergarten student and a toddler. She is also a lapsed runner, an enthusiastic writer, and she maintains a blog, Chaton's World, a working mom's quest for balance in stilettos. Her blog has opened up several doors in her career. She has become a frequent guest on PCNC's Night Talk and has been quoted in several publications, including the New York Times. Ms. Turner also provides consulting services to working mothers. Please join me in welcoming Ms. Chaton Turner for this presentation.
My name is Chaton Turner. I'm Senior Associate Counsel and Vice President of Risk Management and Disability Services at UPMC. And this educational session is going to be about what Pennsylvania physicians need to understand about abortion laws. The learning objectives are to educate physicians about what procedures are covered by the Abortion Control Act, educate physicians about what women are entitled to have an abortion, educate physicians about their responsibilities under the Abortion Control Act, and then educate physicians about what behavior violates the Act and constitutes a crime, as well as unprofessional conduct under the Medical Practice Act and or the Osteopathic Act. Let's get started. Abortion is governed by both federal laws and state law. So, unless you were under a rock, you understand that last June, Dobbs versus Jackson's Women's Health Organization was decided by the Supreme Court, and in that case, it overturned Roe versus Wade and held that the Constitution of this United States does not confer a right to an abortion. Hold the phone. Everybody was up in arms, and it was misconstrued that the consequence of this case meant that abortion was unlawful in these United States, and that is simply untrue. What it said instead is that there's no constitutional right to an abortion under the federal Constitution, which means that abortion in all respects may be governed by the states, which is why you've seen in the headlines different laws in Texas compared to Minnesota, compared to Pennsylvania, for example. Previously, the Roe versus Wade had a baseline that said that abortion was lawful, and states attempted to restrict it in a variety of ways. And the law in this case was a Mississippi law that said that abortion was unlawful after 15 weeks. The court upheld that particular law, and then it went a step further, which actually some legal scholars question whether it was appropriate and also whether or not it's within the constraints of what they can do. But like, who's going to tell the Supreme Court that they can't do it because they're the highest court in the land? But the step that they took after saying that abortion was unlawful after 15 weeks was like, hey, that may have been the law in Mississippi, but we want to actually say something else, and this probably is reflective of the political climate of the court, and we want to say that the Constitution does not recognize or confer a right to an abortion. So any state that would like to make it unlawful, now you can. There was also an executive order in 2020 that dealt with the Born Alive Act that was passed by President Trump. And I actually recently became aware of this because the Born Alive Alive Act, we'll talk more about it later, talks about infants after birth as opposed to discussing the status of a fetus and whether or not it can be aborted. And what this executive order says is that it's the policy of the United States to recognize the human dignity and inherent worth of every newborn or other infant child, regardless of prematurity or disability, and to ensure for each child due protection under the law. And it was expanding upon a concept that was initially introduced under the Bush administration, which in 2002, the Born Alive Infant Protection Act, which affirms legal protection to an infant born alive after a failed attempt at induced abortion. And the President Trump advanced executive order in 2020 was actually articulating an amendment that had been presented in Congress previously, but they weren't able to get it passed. And so the bottom line is that the posture related to abortion in these 50 states has become increasingly more conservative. And what you can also know, and we'll talk about it more in a second, is that Pennsylvania has been conservative and remains so, although we do have the assurance that abortion remains lawful in Pennsylvania. So what does the state law say? In Pennsylvania, abortion is governed by the Abortion Control Act of 1982. And this law also contains its own version of the Born Alive Act. So what does it say in a nutshell? It governs the gestational age, maternal age, establishes a waiting period for abortion, requires informed consent to occur, and informed consent under this law is a particular context that is different from what you already know about informed consent, being risk, benefits, and alternatives. It also contains an obligation to share certain information with someone who's seeking an abortion. It governs minors' access to abortion. In Pennsylvania, you need parental permission or a judicial bypass, which is a judge's order. And then facilities that perform abortions need to register with the Department of Health. And in Pennsylvania, that gestational age is up to 24 weeks. And as indicated, you have to be over 18. So let us be clear. The governing of abortion in Pennsylvania is under the Crimes Code, which means the potential penalty for violating it involves a restriction of liberty as opposed to medical malpractice, which involves paying money. As I mentioned, Pennsylvania is conservative and profoundly pro-life. It starts with saying, because the Commonwealth places a supreme value on protecting human life, it is necessary that those physicians which it permits to practice medicine be held to precise standards of care in cases where their actions do or may result in the death of an unborn child. So as you can tell here, this law applies to all physicians who practice medicine. It is not restricted to people who are board certified in obstetrics and gynecology. It is not restricted to those who practice in the emergency department. It governs the practice of any doctor that has a license in Pennsylvania. So Planned Parenthood versus Casey is a case that was decided in 1992, and it involved the Abortion Control Act. And it went all the way up to the Supreme Court because there was some conflict between certain provisions and it was challenged. And what the Supreme Court held was that the law itself was constitutional. However, there used to be a spousal notification provision that was in the law and enforced, and that was deemed to not be enforceable. Now, one of the interesting aspects of the Dobbs decision is that Justice Alito, who's on the Supreme Court now, was on the Court of Appeals in the Third Circuit, which is the federal circuit that governs Pennsylvania. And he wrote the opinion for Dobbs, and he articulated that it also overturned Planned Parenthood versus Casey, which wasn't even up for debate. And so it begs the question about this spousal notification provision. However, based on the history of the cases deciding Planned Parenthood versus Casey, it does not appear that the spousal notification provision is back, and nobody has taken that position in Pennsylvania thus far, and so we have reasonable confidence that it's not coming back, but it does something that you want to pay attention to if you hear about that discussed in the media. It was in the original text of the law, but then it was overruled by Planned Parenthood versus Casey. So what constitutes an abortion in Pennsylvania? Like, what are we talking about? The reason I wanted to include this definition is you guys are all doctors, you're smart, and you work at UPMC because we believe you're the best and the brightest. So from a medical perspective, I'm sure you understand what this means. You need to understand that in Pennsylvania, the legislature has taken away physicians to define what abortion means to them and has defined what it meant in this particular law. And so what it says is the use of any means to terminate the clinically diagnosable pregnancy of a woman with knowledge that the termination by those means will, with reasonable likelihood, cause the death of the unborn child, except that for the purposes of this chapter, it shall not mean the use of an intrauterine device or abortion or birth control pill to inhibit or prevent ovulation, fertilization, or the implementation of fertilized ovum within the uterus. So the basic concept is any intervention to terminate a diagnosed pregnancy is an abortion. This includes augmenting quote-unquote inevitable abortions for live fetuses. And also note, fetus viability is not used in this definition. Let that sink in for a moment. So what are the penalties for violating the Abortion Control Act? As I mentioned, it's a criminal law, so this, cartoon image is real, potentially. We're talking criminal sanctions, and they range from a summary defense offense, which is a ticket, to a third-degree misdemeanor, and then as you'll see in the Born Alive Act, a felony is actually a potential. So there's an absolute prohibition on obtaining an abortion in Pennsylvania for the purposes of gender selection. So no abortion which is solely sought because of the sex of the unborn child shall be deemed a necessary abortion. The law requires the abortion to be deemed necessary in order for it to occur, and you can't get it if it's for sex selection. So discipline under the Medical Practice Act. One thing you should also know as physicians to understand how seriously this is taken in Pennsylvania is that Pennsylvania legislature as a rule tends to not be the best at drafting. There's a bunch of gaps, but they actually closed all of those as it relates to enforcement of the Abortion Control Act. And so it says right in the text of it that a physician who violates various sections is guilty of unprofessional conduct under the Medical Practice Act or the Osteopathic Medical Practice Act, depending on the act which the physician's licensed. For first offense, the penalty can be what the board deems appropriate, and then the discipline for subsequent offenses can be more. So they have deemed it as unprofessional conduct per se if the physician is found to have violated the Abortion Control Act, and so that means that there will be some sort of discipline as a result, and that's noteworthy because now you're talking about your liberty and your license. What are the legal requirements? Be diligent. Understand the law. Neither ignorance nor philosophical differences are valid defenses against violating the law. And even though you guys are all pediatricians, pay close attention. If you work in emergency departments, pay close attention to this. If you happen to moonlight doing different things, because it would apply to you even if you happen to deliver a baby as a good Samaritan, right? So, spoiler alert, isn't it true that the Abortion Control Act only applies to surgical abortions? No. Under the Abortion Control Act, it is any intervention to terminate a diagnosed pregnancy as an abortion, so that also includes medical abortions. So what if people think my professional judgment tells me the abortion is inevitable, augmenting will make it easier for my patient, so I can do it, right? You probably would not be involved in this decision, but it's not an uncommon one in the world of obstetrics, and the answer to that is no. You know, as I mentioned, any intervention to terminate a diagnosed pregnancy is an abortion, and that includes augmenting inevitable abortions for live fetuses. If you have a live fetus based on the examination, that means anything you do to interfere with that is an abortion. There are requirements for prescribing labor induction drugs for clinically diagnosable pregnancy. So, if, say, a patient is in a peri-viable period and the diagnosis of the infant is really not good, if you are past 24 weeks, which remains, you know, peri-viable, there's this peri-viable period between 22 and 25 weeks from an ACOG perspective, but if you're over 24 weeks and the doctor would like to help things along, the doctor should not help things along if it's going to be an abortion because you're outside of the confines of the Abortion Control Act, and at that point you have to allow things kind of to happen naturally in order to ensure that you don't run afoul of the law. Minimum consultation requirements. Except in a medical emergency, the woman upon whom the abortion is to be performed shall have a private medical consultation either with the physician who's to perform the abortion or with the referring physician. The consultation will be in a place, time, and of duration reasonably sufficient to enable the physician to determine whether or not, based on the physician's best clinical judgment, the abortion is necessary. There's great latitude paid to the physician's clinical judgment, and the only prohibition is the one I mentioned, which is against gender selection. In determining whether abortion is necessary, the physician's best clinical judgment may be exercised in light of all factors, physical, emotional, psychological, familial, and the woman's age relevant to the well-being of the woman. Notably, though, the psychological effect on a woman who is past 24 weeks, which is past the gestational age for abortion is allowed, may not be used to augment that delivery because you're outside of the time when an abortion would be lawful. So informed consent and abortion. The informed consent must be taken 24 hours beforehand. You know, the content of the conversation has to include the nature of the proposed procedure or treatment and the risks and alternatives to the procedure or treatment that a reasonable patient would consider material to the decision of whether or not to undergo an abortion, the probable gestational age of the unborn child at the time of the abortion to be performed, the medical risks associated with carrying the child to term, and then there's also materials that must be provided that are prescribed by the state, which is also why if you're not at a facility that has registered with the Department of Health to perform abortion, you absolutely should not be doing this because you're going to run afoul of the law because your hospital is not going to have those materials. You will also invite an investigation by the Department of Health, and you will cause your hospital to incur sanctions because that has happened to hospitals that you may know. So, however, when a medical emergency compels the performance of an abortion, the physician shall inform the woman prior to the abortion, if possible, of the medical indication supporting his or her judgment that an abortion is necessary to avert her life or avert substantial and irreversible impairment of a major bodily function. And if it is an emergency, a true emergency under this definition, it can be done anywhere, and the facility doesn't need to have a license. We are not in the business of transferring patients that are going to expire on their way to get to a registered facility. So if it's an emergency, it can be done anywhere. Appropriate diagnosis needs to be done from a diagnostic testing perspective to confirm an IUFD, simply because a patient is bleeding profusely does not indicate that an IUFD is present. We have ultrasounds, use them. Good medical documentation is essential. Oh, just for clarity, the slide that was before this was indicating that If there is an IUFD, then you're no longer committing an abortion because it's not a clinically diagnosable pregnancy, right? So if it's an interuterine fetal demise, that means the diagnostic testing has confirmed that the fetus has died in utero, you're not under the Abortion Control Act anymore because you don't have a clinically diagnosable pregnancy. It's only when it's clinically diagnosable, and under those circumstances, as I mentioned, if it's a medical emergency, which means that the physician who is caring for the patient has exercised their good faith clinical judgment and indicated that being pregnant so complicates the woman's health as to necessitate the immediate abortion of her pregnancy to avert her death, or for which a delay will cause substantial and irreversible impairment of a major bodily function, then kind of all bets are off. You can do what's necessary to take care of her. It's a team-based practice, right? And so it's relevant to know that Pennsylvania protects the right of conscience. If somebody on the team does not want to participate because they have some sort of moral objection, they are protected. And this law prohibits all forms of discrimination, disqualification, coercion, disability, or imposition of liability or financial burden upon people who refuse to act contrary to their conscience or conscientious convictions in refusing to obtain, receive, subsidize, or accept, or provide abortions. So nobody can be forced to do it, right? In addition, team members have their own exposure. So all medical personnel attending a child who's born alive during the course of an abortion or premature delivery or being carried to term shall provide such child that type and degree in treatment which in the good faith judgment of the physician is commonly and customarily provided to any other person under similar conditions and circumstances. Anybody who intentionally, knowingly, or recklessly violates the provision of this commits a felony of the third degree. This is found in the Born Alive Act. It's Infanticide, and we will talk about that more in a minute. As I mentioned, regulatory compliance and malpractice suits are not your primary concern under the Abortion Control Act. That's because this is a criminal law and your personal liberty is at stake. So, infant resuscitation in infants born alive, which is probably the most interesting part of this for you, being that you are you're all pediatricians. So, the Pennsylvania Abortion Control Act of 1982 was updated in 2002 after the federal law that George Bush signed, and there's a federal law defining these obligations medical personnel have to infants born alive, and in essence, it's a limitation on the right to choose certain options, right? So the federal law perspective, it addressed concerns about the use of intact dilation and extraction for means other than to save the life of the mother. There was all of this talk about partial birth abortion, and it came up during the Clinton administration and continued to be discussed under the Bush administration. And because of that, was a Republican president and Republican Congress, they were successful in getting this law passed. And so this was the first kind of encroachment against Roe versus Wade. And it defined born alive as the complete expulsion of an infant at any stage of development that has a heartbeat, pulsation of the umbilical cord, breath, or voluntary muscle movement, no matter if the umbilical cord has been cut or if the expulsion of the infant was natural, induced, cesarean section, or otherwise. So, what does Pennsylvania say about this? Pennsylvania actually went further than the federal law and has these requirements. So first, as a beginning proposition, the law of this Commonwealth shall not be construed to imply that any human being born alive in the course or as a result of an abortion or pregnancy termination, no matter what may be that human being's chance of survival, is not a person under the Constitution and laws of this Commonwealth. So every infant born alive is a person, right? Care is required. All physicians and licensed medical personnel attending a child who is born alive during the course of an abortion or premature delivery or after being carried to term shall provide such child that type and degree of care and treatment which in the good faith judgment of the physician is commonly and customarily provided to any other person under similar conditions and circumstances. That means to those under that gestational age, right? Violation of that provision is a felony. The obligation of the physician is whenever the physician or person is prevented by lack of parental or guardian consent from fulfilling his obligations under subsection B, he shall nonetheless fulfill said obligations and immediately notify the juvenile court of the facts of the case. The juvenile court shall immediately constitute an inquiry, and if it finds a lack of parental or guardian consent is preventing treatment required under subsection B, it shall immediately grant injunctive relief to require such treatment. So what does that mean? Yeah, you heard me right. Parents do not have the final say. So for medical providers, it's important to understand that infanticide is a crime. And that means that anything done to facilitate the death of a child that is born alive by those that are involved in the delivery implicates this crime, right? So the assessment, though, is the good faith judgment of the physician, right? They have to provide what's commonly and customarily provided to any other person under similar conditions and circumstances. So if the gestational age or there's some genetic anomaly or something else indicates that it would not be provided under a person under similar conditions and circumstances, it does not have to be, but that physician assessment and documentation is critical, right? And parent refusal to consent to resuscitation is not an excuse, and this is the part that probably is the most offensive to the sensibilities of physicians, because, you know, this is an area, especially in obstetrics, where there's this partnership that is often done as part of the care experience, probably even more profoundly and richly than it is in other areas of medicine. There's this partnership, and women have a lot of input into their health and decision making, especially as you're talking about delivery. I mean, where else in medicine does your plan matter as much, right? There's all this encouragement for birthing persons to have a birth plan. If you go get your knee taken out, right, or replaced, nobody cares what your plan for that is. But in obstetrics, they care and they partner with you. And in this case, there's a break of the partnership because the obligations of the medical providers supersede the interests of parents under these circumstances. And if necessary, they can go to court to enforce that the care will be provided to an infant under those circumstances if that's what the physician concludes would be done and should be done. So what does it mean? What's the bottom line? Parents may choose abortions and providers may perform abortions, but nobody has the right to abandon an infant that is born alive. Professional licensure risk. Violation of any part of the Abortion Control Act, including the Born Alive Act, is a per se violation of the physician licensing regulations. That means it's absolutely a violation and, you know, will be reviewed by the board as such. We talked about the discipline under the Professional Practice Act already. And so what are the option of penalties? They go from civil to criminal. So I mentioned this is a criminal law, but it also has some civil penalties. So any physician who knowingly violates any provisions of Section 3204 relating to medical consultation and judgment or 3205 relating to informed consent shall, in addition to any other penalty prescribed in this chapter, be civilly liable to his patient for any damages caused thereby, and in addition shall be liable to his patient for punitive damages in the amount of $5,000, and the court shall award a prevailing plaintiff a reasonable attorney fees as part of the cost. So that means that $5,000 will be assessed for punitive damages, attorney fees will be assessed, and then there could be compensatory damages of some unknown amount. That would be a part of the case. Licensure penalties. Physician who violates various provisions of the ACA guilty of unprofessional conduct under the Medical Practice Act and or the Osteopathic Act. We talked about that. And then the criminal penalties. Any individual who intentionally, knowingly, or recklessly violates provision of this subsection commits a felony of the 3rd degree. So it's a big deal. That's really what the purpose of this is. And with that, I will end the formal presentation and I will appear live so that we can discuss questions. But I'm glad that I had the opportunity to discuss this law with you in the framework of the federal and the state context because it's not intuitive and all physicians in Pennsylvania really need to be aware of what's required. so that they don't inadvertently violate the Abortion Control Act, and they can provide the best care for their patients when and if the need arises. Thank you for your time, and have a great day.